this court to grant not to grant this application as it is an exercise in futility. They opine that the Supreme Court does not have jurisdiction to look into or act on Exhibit C and D if admitted into the proceedings. The learned senior counsel for the appellants submitted otherwise. I have already summarized their various positions and I shall refer to them as we proceed. It is elementary to state that the judicial court is the authority which a court possesses to decide matters brought before it, or to take cognizance of matters presented in a formal way for its decision. In an old case of Ogun Makun and Milad Osun State, citation supplied, this court stated as follows: jurisdiction of the court is the basis, the foundation, and the live wire of access to court in adjudication under Nigerian civil process. As courts are set up under the Constitution, decrees, acts, laws, and edicts, they cloak the courts with the powers and jurisdiction of adjudication. If the Constitution, decrees, acts, laws, and edicts do not grant jurisdiction to a court or tribunal, the court and the parties cannot, by agreement, endow it with jurisdiction, as no matter how well intentioned and properly conducted the proceedings, once it is incompetent, it is a nullity and an exercise in futility. End of quote. The jurisdiction of a court has further been defined as the very fundamental and priceless community in the judicial process. That is to say, it is the fulcrum, the centerpiece, or the main pillar upon which the validity of any decision of any court stands and around which other issues rotate. Thus, it cannot be assumed or implied. It cannot also be conferred by a party or by consent or acquiescence of parties. A lot of cases have been cited to support this. And that is the general nature of jurisdiction. I must emphasize that the matter under which the application is brought is an appeal in an election petition. It is tried that election petition proceedings are sui generis. It has its own set of laws and rules which a court must recognize and enforce. See Buhari and Yusuf, Egbarioba and Erobo, all citations supplied. In the circumstance of this case, this court, in determining this motion, has to take into consideration the peculiarity of the instant appeal, which is an appeal against the judgment of the Court of Appeal, sitting as the Presidential Election Petition Court, based on the provisions of the Constitution of the Federal Republic of Nigeria and the Electoral Act 2022. I have carefully perused page 1 of volume 1 of the Record of Appeal, and it is very clear that the petition giving birth to this appeal, and particularly this application, was filed on the 21st of March 2023, which was the last day of the 21 days prescribed in section 285 sub 5 of the Constitution of the Federal Republic of Nigeria 1999 as amended for filing of election petitions after announcement of result of election. By subparagraph 6 thereof, an election tribunal shall deliver its judgment in writing within 180 days from the date of filing the petition, and where there is an appeal, it shall be determined within 60 days from the date of delivery of judgment of the tribunal or court of appeal. As pointed out by learned senior counsel for the respondents, the 180 days prescribed for the hearing of the petition by the Court of Appeal lapsed on the 17th of September 2023. In other words, the court below lost its jurisdiction to determine any matter in relation to the petition. This application before us relates to fresh evidence obtained after the judgment of the lower court, and after the 21 days for filing election petition, and after the expiration of the 180 days of the filing of the petition. What are the legal and or constitutional implications of the above scenario in relation to Exhibits A and D sought to be received into these proceedings? Several of the decisions of this court have taken care of the above scenario. One of the most recent cases decided by this court is the case of Towo, Womo, and Ajayi, the citation supplied there, wherein this court stated as follows, and I'll quote, "In the circumstance of this case, this court cannot activate Section 22 of the Supreme Court Act 2004, since the 180 days provided by the Constitution to determine the appellant's claim at the trial court has lapsed since 1st January 2023. The originating summons was filed on the 5th of July 2022 and expired on 1st January 2023 at the Federal High Court. This appeal was taken on 2nd January 2023, and there is no opportunity for the contentious issues of fact in the controversy in this appeal to be sent back to the trial court. The issue of the merit of the allegations of false information was not tried by the two lower courts and cannot be tried by this court pursuant to Section 22 of the Supreme Court Act. This court cannot do what the trial court is no longer constitutionally permitted to do by virtue of Section 285 of the Constitution of the Federal Republic of Nigeria, the Groundnut. See OK, Mimiku, C, APC, and Marafa, all citations supplied. As stated by the appellant applicants in their application, the reliefs they seek is an order of this court granting them leave to produce, and for this court to receive fresh or additional evidence by way of deposition on oath. Clearly, the application runs foul of paragraphs 14 sub 2 and 16.1 of the first schedule to the Electoral Act, which inter alia outlaws any amendment of substance, as in this case, or introduction or addition of substance to the statement of facts relied on to support the ground of the petition after the expiration of 21 days prescribed in Section 132, sub 7 of the Electoral Act for the presentation of an election petition. There is no doubt that the deposition is one of substance, and that is, in fact, why the appellants are seeking to introduce it into this appeal. For the avoidance of doubt, I shall reproduce Section 14.2, paragraph 2A of the first schedule to the Electoral Act 2022 as follows. After the expiration of the time limited by A, Section 132.7 of this Act for presenting the election petition, no amendment shall be made. No amendment shall be made. 1. Introducing any of the requirements of paragraph 4.1 not contained in the original election petition filed. Or 2. Effecting a substantial alteration of the ground for or the prayer in the election petition. Or 3. Except anything which may be done under subparagraph 2A2, effecting a substantial alteration of or addition to the statement of facts relied on to support the ground for or sustain the prayer in the election petition, end of quote. Nothing can be clearer than the above provision, which clearly states that a petitioner shall not be permitted to amend his petition after 21 days allowed by Section 132 sub 7 of the Electoral Act. The applicants herein have not even applied to this court to amend their petition in order to reflect the fact of forgery, and Exhibit C and D sought to be admitted into the proceedings. Facts and documents which were not pleaded in the petition have no place in deciding the dispute between the parties. I still wonder how the appellants intend to use those documents in this appeal. Let me consider an unusual submission of the learned senior counsel for the appellants applicants. It is in respect of section 285 sub 6 of the Constitution, which states, an election tribunal shall deliver its judgment in writing within 180 days from the date of filing the petition. But on page 3, paragraph 2.5 of the appellant's reply on points of law, he argued as follows, quote, interestingly, and contrary to the avowed position of the respondents, we make bold to submit that there is no such constitutional limit of 180 days on the lower court to hear and determine a presidential election petition, such that can rob this court to exercise its jurisdiction in any manner whatsoever. While establishing the election tribunals to deal with election matters from houses of assembly, National Assembly and governorship elections, the Constitution gave jurisdiction to entertain disputes from presidential elections only to the Court of Appeal. Thereafter, the Constitution was intentional and deliberate in setting the 180 days limit only for elections tribunals and not for the Court of Appeal, end of quote. It is shocking to have the above argument in print. It could have passed for a friendly joke, but not for a serious matter like this in the apex court. It is even an unnecessary joke over a constitutional provision. After election petitions had suffered under the previous provisions, which allowed election petitions to be heard even until the respondent has completed his tenure, and the National Assembly dealt with the mischief by limiting the time which election petitions shall be determined, it is unfair to suggest that we go back to those dark days. My lords, there is nothing in section 285(6) of the Constitution to suggest that the Court of Appeal can hear presidential election petition without time limitation. The lower court is bound by the provision of section 285 sub 6 of the said Constitution when sitting to hear election petition, just as other election tribunals, as was rightly submitted by the learned senior counsel for the third respondent, Chief Akin Olujimi SAN, for which I wholly agree. The appellants knew they had to prove the allegation of non-qualification raised at paragraph 16D and 146 of their petition against the second respondent within the 180 days adjudication window provided in section 182 sub 8 of the Electoral Act 2022 for determination of petition by the lower court, which expired since 17 September 2023. The 180 days having expired, the lower court therefore no longer had jurisdiction to allow the deposition sought to be introduced into the trial of this petition. This is the law which at this stage is elementary. Consequently, since the lower court no longer has jurisdiction to entertain any such application, it follows ipso jure that this court, this Supreme Court, also has no jurisdiction to allow the deposition to be used in this appeal. It is settled law that where the time for doing a thing is limited by the Constitution or statute, the court cannot extend the time. That was the decision of this court in Brigadier General Mohammed Buba Mawar and Admiral Murtala Nyako, where Onogan JSC as it then was held as follows. Quote, it is settled law that the time fixed by the Constitution for the doing of anything cannot be extended. It is immutable. It is fixed like the Rock of Gibraltar. It cannot be extended, elongated, expanded, or stretched beyond what it states. See also Abubakar and Nasam, all citations supplied. It has to be noted, as I stated earlier in this ruling, and for which there are several judicial decisions in this country, that the 180 days imposed on election tribunals and courts hearing election petitions is immutable and cannot be extended. The applicants have not even applied for extension of time to bring in the said depositions or extension of time to amend their petition. Let me say it clearly that 21 days provided for the filing of petitions having long expired, even if the appellants had applied for extension of time to amend their petition in order to bring in the depositions, it would not have been granted based on the provisions of the Constitution and the Electoral Act. This principle was again restated by yet again Onogen JSC as it was in NNPP and Goni. Citations applied when he said, despite the decision of this court since October 2011 on the time fixed in the Constitution, some of the justices of the lower court still appear not to have gotten the message. From where will the election tribunal get the jurisdiction to entertain the retrial after expiration of the 180 days assigned by the Constitution? The answer is obviously in the negative. It should be constantly kept in mind that prior to the provisions of Section 285(6) of the 1999 Constitution as amended, there was no time limit for the hearing and determination of election petition by the election tribunals or the appeals arising therefrom. That situation resulted in undue delay in the hearing and determination of an election petition by the election tribunals or appeals arising therefrom. The amendment to the original Section 285 of the 1999 Constitution, by allotting time within which to hear and determine election petition and appeals arising therefrom, is designed to ensure expeditious hearing and conclusion of election matters. If the decision of the lower court is allowed to stand as urged by the respondents, it will reintroduce the earlier mischief which the amendment sought to correct. End of quote. See also Uba and Suswan. Citation supplied. The above statement by this court is very explicit, clear, and simple. As it is, the provision of the Constitution has spoken. There cannot be an addendum or another reopening of the case at the lower court, its jurisdiction having lapsed. My noble lords, I've taken time to state the law on the issue to show the futility of this motion. It cannot be granted. The jurisdiction of this court is donated by the Constitution and the Electoral Act regarding election petition appeals. We do not have the virus to admit this disposition, and we cannot invoke Section 22 of the Supreme Court Act, since the lower court has since lost its jurisdiction. More so, there is no paragraph of the petition to accommodate a case of forgery. Again, the appellants have distilled 7 issues for the determination of this appeal, and none relates to certificate forgery. One wonders what the appellants intended to do with the deposition, since appeals are heard on the issues distilled for determination by the parties in this court. In Saliba and Jackson, 2002, for Nigeria will report, citations, others supplied. This court stated clearly that all appeals are decided upon the issues formulated for determination. What this means is that any matter not covered by any issue for determination is of no moment. Should the deposition be admitted, it will float in the appeal, as this court cannot exercise original jurisdiction, even if we are to start a new case for the appellants. See Sanusi and Ayula, Chitex Industries, and Oceanic Bank, citations supplied. Finally, my noble lords, on this application, I wish to state that fresh evidence is not received as a matter of course. There are conditions which must coexist before the court can grant this type of application, as can be garnered from the decided authorities of this court. which include, but not limited to Onwu Buariri and others, and Igbo Oyosi and others, Supra. Adegbite and a motion are cases cited by the Senior Counsel by the second respondent. Simply put, the conditions for the grant of this type of application are that 1, the fresh evidence could not have been obtained with reasonable diligence at the trial. 2, such evidence, if admitted, would have important effect on the subject of the appeal. 3, such evidence ex facie is apparently capable of being believed. 4, such evidence would have influenced the judgment of the lower court in favor of the appellants had it been available. And 5, and if such evidence is admitted, further evidences from the opposing party would not be needed. Taking the first condition, for example, the appellants failed to convince this court on why it waited until after the court below delivered judgment in the petition and lost the 180 days donated to it by the Constitution before bringing the said deposition sought to be admitted in this court. It has to be noted that appeals are a continuation of hearing of the matter in the lower court. As was pointed out by the learned senior counsel for the first respondent, A.B. Mahmoud Esse, the presidential election was conducted on the 25th of February, 2023. And the first respondent declared the second respondent as winner of the election on 1st March, 2023. Thereafter, the appellants filed their petition at the registry of the court below on 21st March 2023. If I may ask, what attempts did the appellants make between the publication of the second respondent's form EC9 and accompanying documents in June 2022, a year more than a year ago, and the date of filing the petition on 21st of March 2023 to obtain the documents from Chicago State University, which could have been used at the trial court? Again, what attempts did the appellants make to obtain these documents between the date of filing the petition and the conclusion of trial? To say the least, the above questions are critical in the quest of this court's efforts to decide whether the new evidence sought to be adduced could have been obtained by the appellants with reasonable diligence for use at the trial. And with due respect to the appellants and their counsel, I think they were a bit tardy and were not reasonably diligent in their attempts at obtaining the documents which they seek to have this court receive in this appeal. In Adeleke Aserifa Supra, this court held that where the evidence is available and could with reasonable care and diligence be made available to the applicant at the time of the trial, as in this case, the court should refuse to exercise its discretion to receive such evidence. From all I have stated above, it is crystal clear that the additional evidence by way of the deposition of oath does not fit into the issues submitted for the determination of this appeal. The application, my lord, of the appellant applicants in the circumstance is hereby refused and accordingly dismissed. I now go to the main appeal. I want to say that the motions filed by the respondents to challenge some issues, grounds of appeal, we have decided to ignore them, strike them out, and hear the appeal on the merits. The latest senior counsel for the appellants distilled 7 issues for determination, all of them, except the last one, the third respondent submitted 6 issues. So we have stated all there are 7 issues in the judgment. You will see them when you get copies. There is no doubt that all the issues submitted by all the parties are similar, and any could be adopted for guidance. I propose, however, to determine this appeal based on the issues as formulated by the appellants. After all, it is their own appeal. Issue 1. The thrust of issue 1 is whether the lower court was right in refusing to hold that the failure of the first respondent to electronically transmit results from polling units nationwide for the collation of results introduced by the Electoral Act 2022 and specified in the regulations and guidelines for the conduct of elections 2022 and manual for election officials 2023 does not amount to non-compliance, which substantially affected the outcome of the election. Chief Chris Uche, SAN, learned senior counsel for the appellants, submitted in the main that by virtue of Section 64, Sub 4 of the Electoral Act 2022, the collation officers and returning officers of the first respondent, including the national chairman of the first respondent, were under a statutory obligation towards mandatory verifications and confirmations at all stages required before the announcement of the result of the election. Leonard Silk further contended that at the trial of the appellant's subpoenaed witnesses, several INEC presiding officers, including PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25, who handled the BVAS machines at the polling units on the election day, who confirmed the non-transmission of results of the presidential election electronically from the BVAS machines, whereas the results for the National Assembly election held simultaneously were electronically transmitted without difficulty. That the appellant's witnesses gave evidence that the bypass of the use of the prescribed verification technology was nationwide, affecting the entire polling units and collation of results all over Nigeria, and substantially affected the outcome of the election. That the sole witness of the first respondent, Lawrence Biode, admitted under cross-examination that the deployment of the technology of BVAS and IREV was to guarantee the transparency of the electoral process and the integrity of the results, but claimed that there was a technical glitch that made the system fail to work on the election day, which technical glitch was not explained by the first respondent. The appellant contended that the failure to transmit the result electronically led to manipulation of the results in favor of the second respondent. Leonard Silk then urged this court to depart from its previous decisions pursuant to Order 6 Rule 54 of the Supreme Court rules on the manner of proof of non-compliance with the provisions of the Electoral Act in the light of the novel provision in Section 132 of the Act and paragraph 46 of 4 of the first schedule to the Electoral Act. The learned SAN submitted that the assurances given to the public by the first respondent as a public institution that results will be electronically transmitted was dashed. It is his contention that the election ought to be nullified by reason of the gross misrepresentation by the first respondent based on the doctrine of legitimate expectation as applied by this court in Stitch and AG Federation. Citation supplied. The learned still concluded on this issue that given the introduction of technology into the collation process by the new Electoral Act 2022, the judicial approach and the attitude must of necessity be different from the analog past. He then advised this court to depart from its decisions on mode of proof of non-compliance with the Electoral Act in election petitions, as was the case in Nyesom Wike and Peterside, Okereke and Umahi, Shinkafi and Yari, amongst others. He urged the court to resolve this issue in favor of the appellants. In response, the learned senior counsel for the first respondent, A.B. Mahmoud Hussain, urged this court to decline the invitation to override its previous decisions on the manner of proof of non-compliance because such invitation is not usually taken lightly by this court. He contended that the conditions for such application does not exist in this appeal, relying on VP Industries Limited and Cocoa Industries Limited citation supplied. He contended that the appellant has not contended that the previous decisions sought to be departed from were given per incuriam or erroneous in law. On the argument that first respondent failed to electronically transmit results, he submitted that the only reference to electronic transmission of polling unit results appears in paragraph 38(1) of the guidelines published by INEC for the conduct of the election, wherein it provides that presiding officers shall electronically transmit or transfer results of the polling units directly to the collation system prescribed by the first respondent. That the use of the word "or" in the said paragraph 38(1) of the guidelines gives the presiding officer the discretion or option to either transmit electronically or transfer the result to the collation system prescribed by the first respondent. Learned Senior Counsel submitted that the main complaint of the appellants relates to the alleged failure to transmit the election result to the IREP portal for members of the public to view, and that this amounts to non-compliance. He submitted that the IREP portal is only a public viewing portal and not a collation portal, relying on Oyetola and INEC citation supplied. He urged the court to hold that the failure did not substantially affect the result of the election, which was properly collated and result announced. In his argument, Chief Olanikpe Kunese, for the second respondent, submitted that by all extant relevant laws, INEC has the prerogative of determining the mode and manner for the transmission of election results, and that the lower court was perfectly right, and in order when it so held. He faulted the appellant's claim and basis of allegation of non-compliance with respect to the presidential election in focus on their claim that the results of the election results were not electronically transmitted to the IREP in real time, not that it was not transmitted at all, and that the first respondent did not ensure that the results were collated on the IREP. He also faulted the appellant's insistence that the results ought to have been collated electronically on the IREP, and that omitting to do this automatically nullified the result of the election. Referring to the case of Labour Party and INEC, suit number FHC ABA-CS 145/2022, delivered on 23/1/2023 by Wite J of the Federal High Court, which decided that there is nothing in the combined reading of sections 47(2), 52, 65, and 62(1) and 2 of the Electoral Act 2022, which suggests that INEC is mandated to only use an electronic means in collating or transferring of elections result. Rather, that INEC is at liberty to prescribe the manner in which election results will be transmitted. That by section 287(3) of the 1999 Constitution, all authorities and persons are bound to enforce the terms of the judgment until set aside by an appellate court. He submitted that all through the gamut of the Electoral Act, the appellants were unable to refer to the lower court a single provision which prescribed electronic collation of result or even electronic transmission of results, and that was why the court below held that the petitioners were unable to prove that the Electoral Act or guidelines made it mandatory for electronic collation system. He submitted further that the appellants failed to show that the results collated was different from the one they perceived belonged to them. Learned Soul submitted finally that the Electoral Act 2022, the INEC regulations and manual points irresistibly to a manual collation of results, contrary to electronic collation touted by the appellants. The reason being that by paragraph 93 of the regulation, the only circumstance where electronic copy of results becomes relevant is where there is no hard copy of the result. Then the electronic copy can be resorted to during collation. Learned counsel Olanik Bekun urged this court to resolve this issue against the appellants. In his submission, Chief Olujimi SN, for the third respondent, submitted that the appellants seem to have admitted their failure to prove allegation of non-compliance when they pleaded with this court to depart from the earliest established legal position that non-compliance be proved on polling unit basis. He submitted that there is nothing compelling presented by the appellants to warrant a departure from the established legal order, relying on Wike and Peter's side, Belgore and Ahmed citations supplied. He urged this court to decline the invitation. According to Leonard Silk, any arguments for relaxing the established standard of proof of allegation of non-compliance must not be driven by sentiments and cavalier presentation of a case seeking to overturn the will of millions of the electorate in a presidential election. He contended that the appellants merely half-heartedly offered 27 witnesses, many of whom were incompetent witnesses, while purporting to prove allegation of non-compliance, covering 176,000 polling units spread across the 36 states that make up the Federation of Nigeria. He argued that based on the inadequate evidence, the allegation of non-compliance must fail, relying on Buhari and Obasanjo, Atiku Abubakar, and INEC, all citations supplied. He urged the court to resolve this issue against the appellants. In their reply brief, the learned senior counsel for the appellants faulted the response of the respondents in relation to their call for this court to depart from its previous decision touching issue of non-compliance. According to him, his argument is based on the introduction of Section 65 and 6 and 187 of the Electoral Act 2022 and paragraph 46 of 4 of the first schedule to the Electoral Act, which provisions were not in the 2010 Electoral Act. That these new provisions deal with the new manner of transmission of result as contained in paragraph 38(1) and 2 of the Regulations and Guidelines for Conduct of Elections 2022 and the legislative intervention to reduce calling of numerous witnesses. This is what the court has to say. By Section 135, sub 1 of the Electoral Act 2022, an election shall not be liable to be invalidated by reason of non-compliance with the provisions of this Act if it appears to the election tribunal or court that the election was conducted substantially in compliance with the principles of the Act and that the non-compliance did not affect substantially the result of the election. From the provisions of the Act stated above, it is crystal clear that a petitioner seeking to nullify an election on the ground of non-compliance must not only lead evidence to prove the non-compliance, but must also show to the court how the non-compliance substantially affected the outcome of the election. A petitioner in this situation must therefore adopt a kind of double-barrel approach. You don't fire one barrel and leave the other intact. Both must be fired together at the same time. From the evidence as can be garnered from the record, the judgment of the court below and the arguments of both parties in this appeal, one thing is very clear, and that is the appellants abandoned the duty imposed on them to lead credible evidence to prove non-compliance, but relied solely on the failure of the first respondent to transmit result real time to the IREF portal. According to the appellants, this was enough to nullify the election of the second respondent. What exactly is the IREF portal? The court below held that the IREP portal is not a collation system. This court in Oyetola and INEC made it clear that there is a difference between a collation system and the IREP portal, though both are part of the election process. Whereas the election system is made up of the centers where results are collated at various stages of the election, the INEC result viewing portal is to give the public the opportunity to view the polling unit results on the election day. What this means is that where the IREP portal fails, it does not stop the collation of results, which up to the last election was manually done. The failure or malfunctioning of the IREP deprives the public and even election administrators and monitors the opportunity of viewing the portal and comparing the result collated with the ones transmitted into the IREP. Truth must be told, the non-functioning of the IREP may also reduce confidence of the voting public in the electoral process. My lords, the Electoral Act empowers the first respondent to determine the electronic device to be used during election and their purpose. The lower court held that the IREP is not a collation system, and I agree. I refer to paragraph 93 of the first respondent's guidelines and regulations for election, which provides that, and I quote, where the INEC hard copy of collated results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the IREP portal to continue collation. When none of this exists, the collation officer shall ask for duplicate hard copies issued by the Commission to the following in the order below. 1, the Nigeria Police Force, and 2, agents of political parties. End of quote. Paragraph 93 of the first respondent's guidelines and regulations reproduced above shows clearly that recourse to the electronically transmitted result for the purpose of collation will only arise where the hard copy of the result sheet does not exist. Given when the electronically transmitted result or the result on the IREP portal does not exist, the Commission will ask the copies handed over to the Nigeria Police or agents of political parties. The elaborate arrangement made by the first respondent for collation of results is to make sure that at every point of collation, there is a result either from the hard copy with INEC or the electronically transmitted copy or the IREP portal copy or a hard copy given to the Nigeria Police, and finally, or a copy given to political parties. I think I can confidently say, and in agreement with the respondents, that the unavailability of the election results on the IREP portal, for whatever reason, cannot be a ground upon which an election could be nullified, particularly as it is not the case of the appellants that the hard copies of the result sheets did not exist at any level of collation. My lords, having failed to prove necessary, if and only if originals or certified true copies manifestly disclose non-compliance. In this case, the appellants have not demonstrated the originals or certified true copies of documents they want the court to rely on. Given where such documents are tendered in evidence, it is to be shown that they manifestly disclose the non-compliance. On the whole, it is my well-considered opinion, which accords with the views of this court, with the court below, that the failure to transmit result to the IREB did not affect the result of the election. Accordingly, this issue is resolved against the appellants. The second issue is whether the court below was right in its interpretation of the provisions of Section 134, Sub 2B, and Section 299 of the Constitution of the Federal Republic of Nigeria as amended, in holding that securing 1/4 of the total votes cast in the Federal Capital Territory, Abuja, is not a constitutional requirement for the valid return of a candidate as duly elected President of the Federal Republic of Nigeria. In his argument, the learned senior counsel for the appellants urged this court to interpret the word "and" in Section 134 2B of the Constitution conjunctively and not disjunctively, which will make it compulsory for a candidate to score a quarter or 25% of votes cast in the Federal Capital Territory before he can be President of the Federal Republic of Nigeria. The respondents argue otherwise. My noble lords, on pages 8234 to 8235 of Volume 10 of the Record of Appeal, the lower court made the following decision, and I quote, "As expressly stated in Section 299 of the Constitution for the purposes of fulfilling the requirements of Section 134 Sub 2B of the Constitution for the return of a presidential candidate as duly elected, the Federal Capital Territory, Abuja, is to be treated as one of the states in the calculation of 2/3 of the states of the Federation, such that if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the Federation, FCT inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to secure 25% of the votes cast in the Federal Capital Territory, Abuja, as the second respondent did." End of quote. To be very honest, I do not see anything wrong with the above decision. It is basic that one of the vital concerns of interpretation of statutes is that a court of record should be minded to make broad interpretation, or what is sometimes referred to as giving SEM a liberal approach. A court should give a holistic interpretation to a statute or the Constitution as required by law. Probably I may add that a court must give the Constitution or a statute a purposeful and people-oriented interpretation. What I'm trying to say is that in interpreting the Constitution or any statute for that matter, a narrow and selfish approach should be avoided. The duty of the court in interpreting statute should be in such a way that it serves the generality of the people and not for a select few. It is trite that the legislature does not intend creating injustice or an absurdity. Hence, the court must always adopt a construction or interpretation which will not reduce legislation to futility and absurdity. See Governor of Kwara State and Dada, citation supplied. Let me drive this matter home. The poster rendered by the learned senior counsel for the second respondent in their brief comes handy. Assuming that a candidate scores the highest number of votes in a presidential election and has 25% or 1/4 of votes in 30 out of 36 states and Abuja, but failed to secure 25% in the FCT, are we saying that he cannot be president? Is that what the Constitution intended? I don't think so. The court below made it very clear when it held that if the framers of the Constitution had wanted to make the scoring of 1/4 of votes cast in the Federal Capital Territory a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly separate the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. End of quote. The above decision of the lower court is unassailable, and I have no difficulty in agreeing with it. I see no merit in this issue, and I resolve it against the appellants. Issue 3 calls on this court to interrogate the decision of the court below and answer the question whether the lower court was not in error to have expunged the witness statements on oath of appellant subpoenaed witnesses, namely PW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, and the exhibits tendered by them on the ground that the witnesses' statements on oath were not filed along with the petition, and that Order 3, Rule 2 and 3 of the Federal High Court Civil Procedure Rules 2019 is not applicable in election matters. He submitted that the interpretation given to paragraph 45B of the first schedule to the Electoral Act 2022 by the lower court in disallowing the testimonies of the appellant's subpoenaed witnesses will only lead to absurdity and prevent petitioners from compelling relevant evidence in possession of an adversary. In reply, the 3 senior counsel for the respondents in their various briefs submit in unison that the 21 days prescribed for filing the election petition cannot be extended under any guise, and that paragraph 45B of the first schedule to the Electoral Act cannot be enlarged to accommodate witnesses' statements on oath, which were not filed along with the petition. That having responded to the petition based on the facts and witnesses' statements front-loaded, their right to fair hearing will be trampled upon by allowing new evidence through those witnesses when they have no right to further reply. They urge the court to resolve this issue against the appellants. Let me reiterate the already tried position of the law that election and bound by their rules under the law. It was further held that defects or irregularities which in other proceedings are not sufficient to affect the validity of a claim are not so in an election petition. A slight default in compliance with a procedural step could result in fatal consequences for the petition. It has to be noted that rules governing civil proceedings are not the same which govern election proceedings. And where the Electoral Act requires recourse to civil procedure rules, it must be made subject to the provisions of the Acts. My noble lords, a combined reading of Section 285, sub 5 of the Constitution of the Federal Republic of Nigeria as amended, and paragraph 45 of the first schedule to the Electoral Act 2022 shows that the time limit for the filing of written statement on oath of witnesses, the election petition proceedings, is 21 days from the date of declaration of results. As was pointed out by counsel for the respondents, due to the sui generis nature of the election proceedings, amendment to the petition or calling of additional witnesses will not be entertained after the statutory time limit for the filing of petition has expired. Thus, a petitioner cannot present his case in bits, otherwise the respondent's right to fair hearing will be breached. This was the position of this court in OK and Mimiko citation supplied. In his contributory judgment in the above case, Clara Ogumbi JS retired made the following decision, and I quote: by paragraph 4, sub 1 and 5 of the first schedule to the Electoral Act, a composite analysis of the contents of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive. It is mandatory and conclusive. In other words, the provisions do not allow for additions, and hence the procedure adopted by the appellants in seeking for extension of time is nothing other than surreptitious attempt to amend the petition. Expressly, there is no provision in the legislation which provides for extension of time. What is more, via paragraph 14.2 of the first schedule to the Electoral Act, the appellant by section 134.1 of the Act had been totally foreclosed from any amendment, which was in fact the hidden agenda promoting the application. Further still, and on a critical perusal of the application, Relief 2 seeks leave to call additional witnesses, to wit AEO. It is pertinent to restate that at the close of pleadings, parties had submitted the list of witnesses who were to testify together with their deposition. The idea, purpose, and intention of the application is suggestive of nothing more than a clear confirmation, seeking an order for an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions of section 285 sub 5 of the Constitution and section 134 of the Electoral Act. End of quote. It has to be emphasized that the use of the word shall in paragraph 4.1 and 5 of the first schedule to the Electoral Act makes it mandatory and conclusive. The question may be asked, can a court extend time circumscribed by the Constitution for a party to do a thing he could not do before the expiration of the time? The obvious answer is no. Such provisions like section 85 sub 5 of the Constitution are mandatory, and any exercise of discretion by the court is without jurisdiction and therefore a nullity. In APC and Marafa, citation supplied, this court held that applications for extension of time to call additional witnesses and to file additional witnesses' statements after the prescribed period for presenting election petition are not permitted because election matters are time-bound, and by reason of being sui generis, the procedure in handling them are stricter than ordinary civil matters. See also Ararume and INEC citation supplied. Then learned counsel for the appellants had argued that the law does not compel the impossibility and that subpoenaed witnesses should be allowed to testify. But as was argued by the learned senior counsel for the first respondent, A.B. Mahmoud SN, subpoenas are not a tool with which to circumvent the provisions of the law and the effect and purpose of section 285 sub 5 of the Constitution of the Federal Republic of Nigeria and paragraph 4.5 of the first schedule to the Electoral Act 2022. It is on this note that I hope that the decision of the court below to strike out the offending witness depositions cannot be faulted. I resolve this issue against the appellants. Issue 4 orbits around the evaluation of evidence of PW1, PW2, 3, 5, 7, and 22, who were the appellants' collation agents at the court below. The appellants are aggrieved by the verdict of the court that the evidence of these witnesses were hearsay, thus inadmissible under the rule of evidence. For the purpose of clarity, I shall herein reproduce, albeit extensively, the observation of the court below, which led to the verdicts complained about as follows. Quote, the petitioners, it must be underlined, pleaded in paragraph 4 of the petition that the petitioners had agents in all the polling units, ward collation centers, local government collation centers, and state collation centers in all the states of the Federation, and the Federal Capital Territory, as well as the National Collation Centers. Of this crowd of agents, the petitioners did not call any of their agents at the polling units. The said agents at the polling units were the ones who were meant to sign and collect duplicate results in Form EC8A. The few agents called were state and national collation agents. Largely, their testimonies were hearsay. Let us now examine their evidence before the court. The PW1 is Captain Joe Agada, retired. His statement on oath is at pages 198 to 200 of the petition. He was the petitioner's collation agent for Kogi State. In paragraph 7, 8, and 11 of his statement, he deposed that from the analysis, he discovered various forms of non-compliance and corrupt practices such as suppression of votes, manipulation of the beavers machines, manipulation of accreditation, intimidation and harassment of voters, massive thumb printing of ballot papers, etc. This witness did not give particulars of these malpractices. There was no forensic report to support allegation of thumb printing at the polling units. In PDP and INEC citation supplied, this court, per agim JCA, as it then was, held that it is only a polling unit agent or a person who was present at the polling unit during polls that can give admissible evidence of what transpired during the poll in that unit. See some cases cited there. In the instant case, PW1 was not a polling agent. He was a collation agent. When cross-examined, he said he would be wrong to say that he was present when all the ballot papers and boxes were manipulated, that he visited only 20 polling units out of the over 3,000 polling units in Kogi State. He admitted that his party had polling agents in all the polling units and that they were still alive. The PW2 is also a collation agent. His witness statement on oath is at pages 213 to 215 of the petition. His statement is similar to that of the PW1. He is Dr. Folarin Sunday Adekunle. He was the collation agent of the petitioner for Ogun State on the election day. Under cross-examination, he said he only visited 19 polling units out of the 5,040 of the polling units in Ogun State. PW3, PW4, 5, 6, 7, 8, 9, 10, 11 are all collation agents. The evidence of these witnesses centered around the events and the duties they carried out by the polling units agents of the petitioners. They agreed under cross-examination that the polling unit agents functioned very well in their units under our law. Specifically, in Section 43 of the Electoral Act 2022, polling agents are permitted to be appointed by political parties for each polling unit and collation center. The wisdom in this is for each of the political parties involved in an election to be represented by its own agents. The duties of an agent are to represent the interests of his or her principal. Having regard to the fact that no mortal can be in all the places at the same time, the law allows political parties to have their agents at all polling units and collation centers. It is therefore not anticipated by law for any political party to appoint an office with its tackles in all the polling units and collation centers. This is humanly not practicable. When therefore evidence is required to prove what happened in any polling unit or collation center, it is only the agent who witnessed the anomaly or the malfeasance that can legally and credibly testify. It follows, therefore, that PW1, PW2, PW3, PW4, PW5, 6, 7, 8, 9, 10, 11, 19 2022 who were state and national collation agents of the petitioners can only testify of the events in their units or collation centers where they voted or acted as agents, and not all over the states of the Federation. The polling agents, as presented in this petition, it must be noted, are not shown to be experts. The issue of their analyzing results of the election at the ward, local government, state, and national level without calling polling unit agents who witness the real casting of votes and events at the voting units cannot therefore arise. They cannot validly testify as of non-compliance at the polling unit level. Their evidence can only count as to what they saw, not what they were told by their field agents. What they were told is hearsay evidence. Section 38 of the Evidence Act 2011 specifically states that hearsay evidence is not admissible except as provided for in the law. It follows that the evidence of the collation agent destruction of voting are inadmissible hearsay and are hereby discounted as end quote. Without reservation, I endorse the above statement of the lower court, which is consistent with plethora of decided cases on the subject. Buhari and Obasanjo, Ladoja and Jumobi, and others cited. From the evidence on record, it is indisputable that PW 1, 2, 3, 5, and 7, who were the appellant state collation agents and national collation agents, were not present in all the polling units, which results they have disputed, which means that their evidence in respect of all the polling units, other than the ones that they were present, were clearly hearsay. They were most likely informed by the polling unit agents who were alive but failed to testify. I must say that the above statement of the lower court had nothing to do with the court's failure to ascribe probative value to documents put in evidence pursuant to Section 137 of the Electoral Act 2022 and paragraph 46(4) of the first schedule to the Electoral Act, as vehemently submitted by the appellants. Indeed, the point is instructive in view of the fact that the court had earlier on page 8,102 of the record rejected and overruled the third respondent's preliminary objection, seeking that documents tendered by the appellant be expunged for being dumped on the court. The finding of the lower court in discountenancing the evidence analysis of PW 1, 2, 3, 5, and 7, same being based on hearsay, cannot be faulted. More so, the appellants have not presented any argument to warrant the interference of this court with the finding of the lower court. The issue, again, is resolved against the appellants. Issue number 5 is whether the lower court was not in error in striking out several paragraphs of the petition and the replies of the appellants on the ground of vagueness and lack of specificity, and for being new issues, mere denials, or being repetitions. Well, this issue relates to the ruling of the court below on the first respondent's preliminary objection, seeking an order of court striking out 31 paragraphs of the petition on the ground that they were vague, generic, imprecise, and lacking in specificity to elicit reply from it, and contrary to paragraph 4.1 of the first schedule to the Electoral Act 2022. The court, after scrutinizing each of those paragraphs in a well-considered ruling, struck out 10 paragraphs, namely 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 for being vague, imprecise, and lacking in particulars. For the purpose of clarity, the court held on page 8025 to 8026 of the record as follows. The sum total of all the foregoing is that while paragraph 129 and 133 of the petition are liable to be struck out for non-joinder of necessary parties, to which Messrs. Adejo and Governor Yahya Bello of Kogi State, accused in the petition of committing electoral malpractices, paragraph 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack of particulars, and so fall short of the requirements of paragraph 4 sub 1b of the first schedule to the Electoral Act 2022. They are therefore all others struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 110, 111, 112, 113, 14, 115, 116, 118, 119, 120, 122, 125, 130, 134, 138, 139, 140, 141, 42, 145, on the other hand, are in order and properly pleaded, end of quote. Picked by the above ruling, the appellants now seek the interference of this court on the ground that their vehemence were sufficiently detailed. They also question the decision of the court, striking out their replies to the respondents' replies to the petition. For instance, as touching on the disqualification of the second respondent from contesting election for the office of president, which particulars were supplied in the appellant's reply. It is instructive to note that in paragraph 146 of the petition, the appellants simply averred that, quote, the second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, end of quote. They did not supply the particulars of the threshold, which they perceived disqualified the second respondent from contesting the election, as enumerated in section 137 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Howbeit, in their reply, the appellant ruled out monstrous particulars of disqualification by reason of dual citizenship, allegation of being an ex-convict in a USA district court, having forfeited to the USA the sum of $460,000 in a drug-related case, Note that these particulars referred to as further details were brought in by the appellants at the time when the respondents had lost their right of reply, which in essence offends the cardinal principle of fair hearing expressed in the Latin maxim Audi Alteram Partem, meaning let the other side be heard as well. Paragraph 4 sub 1 of the first schedule to the Electoral Act 2022 provides that an election petition shall A, specify the parties interested in the petition, in the election petition, B, specify the right of the petitioner to present the election petition, 3, state the holding of the election, the scores of the candidates, and the person returned as the winner of the election, and 4, state clearly the facts of the petition and the grounds on which the petition is based and the relief sought by the petitioner. It is clear beyond a peradventure that the requirements of the law is as provided above, is that the petition must demonstrate with specificity the complaints of the petitioner and the relief sought from the court. It gives no room for vagueness and imprecision. This is in line with the rule of pleading, that where an averment is not supported by evidence, the averment is deemed abandoned. For, in keeping with the Audi Alteram Partem rule, to prevent surprise or ambush on the defendant, it is the plaintiff's claim that will enable him to file his defense. See Wayne West Africa Limited and Econife citation supplied, Akonde and Adisa and another citation supplied, PDP and INEC citation supplied. It follows, therefore, that a petition must be detailed and comprehensive on material facts depending on the relief sought, and not evasive or vague, so as to elicit a response from the respondents. Indeed, by the provision of paragraph 16, sub 1A of the first schedule to the Electoral Act 2022, the Act frowns at the introduction of new facts, grounds, or prayers tending to amend or add to the averments of the petition in the petitioner's reply. In fact, a petitioner is only required to file a reply in answer to new issues or facts which may be raised in the respondent's reply, which were not dealt with in the petition. This means that where there are no new issues or facts raised in the respondent's reply, there would be no need for the petitioner's reply. See Oni and Oyebanji, citation supplied. I have critically considered the arguments of parties contained in their respective briefs of argument vis-a-vis the record of appeal. The affected paragraphs of the petition relates to allegation of wrongful cancellation of polling unit results in various local governments in Sokoto State without particulars, manipulation of results in unspecified polling units in some local government areas of Kogi State, wrong results entered for the appellants in unspecified polling units in Borno State, criminal allegations against Honorable Adejo and Governor Yaya Bello without joining them as parties to the petition, open-ended allegation of disqualification against the second respondent, and tying critical allegations of corrupt practices in the election to a statistician report prepared by one Samuel Odutan, that's PW21, without serving the said report on the respondents along with the petition to enable them respond thereto. I am unable to agree with the appellant's argument that the lower court was wrong to have struck out the affected paragraphs for disclosing no particulars, together with some replies in the appellant's reply brief, which sought to bring in new evidence through the back door. I uphold the decision of the lower court, striking out the affected paragraphs and replies of the appellants for being vague, imprecise, lacking in particulars, and seeking to ambush the respondent via the petitioner's replies. The ruling of the lower court is unassailable, and this court will not interfere. This issue, again, is resolved against the petitioners. Issue 6 is whether the lower court was not in error in its evaluation of the evidence of the appellant witnesses on the burden of proof and clear admission against interest made by the first respondent. This issue turns on the averment of the first respondent in paragraph 8 of his reply to the appellant's petition, that the appellants in this case won the contested election in 21 states out of the 36 states of the Federation, namely Adamawa, Akwa Ibom, Bauchi, Bayelsa, Borno, Delta, Ekiti, Gombe, Jigawa, Kaduna, Katsina, Kebbi, Kogi, Kwara, Nasarawa, Niger, Osun, Sokoto, Taraba, Yobe, and Zamfara states. The appellants contend that such averment is tantamount to admission against interest by the first respondent. They therefore question the declarations to return of the second respondent as the winner of the said election. On its part, the first respondent contended that its said admission is of no consequence, having regard to the fact that the appellant scored 6,984,520 votes, as against the second respondents who scored 8,794,726 votes. That in determining the winner or loser in an election to the office of president, the number of states won by a candidate merit any consideration except in the context of geographical spread and ensuring compliance with the constitutional requirements. In its evaluation of evidence on the issue, the court below on page 8238 of the record had this to say, quote, The table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So, where the complaint in an election petition is that the candidate returned did not poll majority of the highest votes in the election to be returned, as contended here by the petitioners, not only must the figures disputed be pleaded, the figures of votes the petitioner perceives as correct figures of the election ought to and must be pleaded. The court went further to hold on page 2854 of the record that, quote, Section 134 sub 2 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the results declared by her in the absence of any rival or alternative result placed before this court by the petitioners, that the second respondent, who scored 8,794,726 votes as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election, end of quote. The above statements, qua holding of the court, represent the correct position of the law, and I wholly endorse them. I have earlier in this judgment resolved the issue of electronic transmission of results, which is the main thrust of the appellant's contention in this appeal. I shall not revisit the point under this issue. On the contention that the first respondent's averment that the appellant won 21 states out of 36 states of the Federation, thus constituting an admission against interest, the position of the law is well settled, having regard to who can be declared winner of a presidential election in Nigeria. Section 134, sub 2 of the 1999 Constitution makes it explicit that, quote, a candidate for an election to the office of president shall be deemed to have been duly elected where there being more than two candidates of the election, A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja, end of quote. In this appeal, the issue before us is not who among the candidates won in the majority of the states of the Federation, which is debatable, but who scored the highest number of votes at the election. I have strenuously combed through the respective briefs of the parties vis-a-vis the record of appeal. I am unable to find any alternative figure put forward by the appellant as their rightful votes scored in the election, other than the scores presented by the first respondent, INEC, showing that the second respondent scored the highest number of votes. It is presumed correct. In the case of Abubakar and Yaradua, citation supplied, this court held that, and I quote, election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption, end of quote. See also CPC and INEC, Buhari and Obasanjo, Hashidu and Goje, all citations supplied. Following from the above, it is clear that the appellants, having not put forward their perceived rightful score to rebut the results put forward by the INEC, the law presumes the first respondent's version as correct. It would not matter whether the appellant can prove having won more states or if the first respondent admits that much. The figures before us show that the second respondent won the highest number of votes and was accordingly returned elected. From whence, therefore, would we manufacture evidence to support the appellant's claim that they scored the majority of lawful votes cast at the election, or that there was non-compliance with the Electoral Act, which affected the credibility of the election? Nowhere, definitely not from the evidence on the record. And that is why this issue is resolved against the appellants. Finally, let me say a few words concerning issue number 7, which is whether the lower court was right in its use of disparaging words against the appellant in its judgment, evincing hostility and bias against the appellants, thereby violating their right to fair hearing and occasioning grave miscarriage of justice. I have read the judgment of the court below, and I've seen the context which those words were used, and it is my view that they were not meant to disparage the appellants or their counsel. As judges, we are trained to be temperate in our use of words, and we shall continue to do so. Litigants are advised to trust the court whenever their matters are before it. It is very unbecoming these days that while a matter is pending in court, litigants engage in press conferences, analyzing the case, reaching conclusions. Based on this, some of their followers send threatening messages to judges and justices. Matters in court are said to be sub judice, and as such, parties, and probably their counsel, should refrain from media trial and media judgments. I need not say more on this. A word is enough for the wise. This issue has nothing positive to offer the appellants. On the whole, having resolved all the issues against the appellants, it is my view that there is no merit in this appeal, and it is hereby dismissed. The judgment of the court below, delivered on the 6th of September 2023, affirming the election of the second respondent as the duly elected President of the Federal Republic of Nigeria, is hereby affirmed. I shall make no order as to costs. My learned brother on my right will deliver his judgment.
Having had a preview of the judgment of my learned brother, John Ian Ikoro, JSC, availed me with a copy of the said judgment just delivered in SC/CV/935/2023. Atiku Abubakar and the Independent National Electoral Commission and others. I completely agree with the critical analysis of both the oral and documentary evidence presented before us in this appeal. Therefore, I agree with my learned brother that the motion of the appellants filed on the 6th of October 2023 for leave to the appellants to adduce fresh or additional evidence is devoid of any merit. I also dismiss the same. On the main appeal, My learned brother resolved all the issues, the 7 issues against the appellant. I therefore agree with him that the issues in the main appeal are devoid of merit